I want clarification, even though you touched it this with your last statement, and that is with regards to the Justice Danagogo's judgment. The learned fellows, as you are, both of you are learned, have always argued on my platform with regards to vacating an order, for an order not to take effect anymore. The question is, did Martin Amaewhule at any point in time appeal that order or appeal to vacate it? Was it ever done? If it was not done, is that order not subsistent? Isn't that the strength of the Okojombo's faction?
Good. From record, I am not aware that Amaewhule and his people, appealed that particular Danagogo, order.
Okay.
The Danagogo order was talking about speakership. Let's be very clear on that. Not the tenure. It was talking about speakership because there was something, the substantive matter has not been taken. And the speaker is saying that this is the man that is recognized by law. Other people, having gone. So this is the man that is recognized by, to be the speaker. This is the man recognized as the speaker. Drawing his powers from the here, whatever. Because the judgment here got was on the speaker, not the personality. Now, in that particular case, I don't think that order or ex parte order was appealed. On the other hand, like I explained, if it was not appealed, an ex parte order extinguishes after 7 days until it is renewed by the party. The court will not renew it sumo motu on its own. It is a party that will apply for the renewal of that particular ex parte order. And once that is not done, because from record I don't have that it was done.
Right.
Yes.
And since that is not done,
yes. That order terminates.
Because it was an ex parte order.
It will terminate like the lifespan of the mosquito that stays for just 72 hours. The mosquito will give birth and hatch their eggs in 3 days' time. If you like, give the mosquito blood inside, pack the whole blood in this essay to go and pour on his body. He dies a natural death. So, from my own take on this, the ex parte order, if not renewed, dies a natural death. Right. So, morticians are working on the ex parte order. They are embalming it. They are buried it.
Right.
Okay. Yeah. Let me distinguish between issue of tenure elongation and that of declaring the seat of an assembly member vacant. That's not what a court will, you don't need the power of the court. Instead, the Constitution says that the Speaker of the Assembly will declare such seats vacant upon their defection. So what Edison did upon the assumption of as a speaker, declared by the reason of their defection to another party, declared their seats vacant. Now, let me also come to the we have interim order which came by ex parte, and that is to the extent that, look, this thing is urgent and we cannot wait until the other party is notified. Please give us this thing, upon which the other party is mandated to appear within a certain period, which is the motion on notice. And a decision is given to that extent when the motion on notice came. What Danagogo state order is an interlocutory order. Let this situation remain pending the determination of the matter. So it does not expire. It's pending the determination of the substantive case.
Well, you said earlier there was an interim order that came.
I said that is the first state. The first state is ex parte.
Interim order. Interlocutory injunction was given.
Good. Pending the determination of the case, and that one does not expire until the issue is to preserve the rest, is to preserve the fruit of judgment, so that at the end of litigation, whoever wins should benefit the fruit of his or her labor. So it's not every interlocutory order, you understand, that just expire at 7 days period. It depends on the order that was given. And this one was tied to the substantive matter, to the determination of the substantive matter.
The substantive matter was the speakership of Edison.
No, yes, the speakership, the Edison, and the declaration of their seat vacant.
All right.
No, that's not.
That is it.
The declaration of their seats vacant.
Yes, that's what Edison did now.
Upon assumption. No, we are not mixing Edison's action with Danagogo's judgment. They are two different things. No, what
is the premises? How would Okojumbo? Let me explain. You asked the question. How will Okojumbo derive legitimacy if the Danagogo did not deal with the vacancy of the Amaewhule's and his former assembly members' seat? It is based on that. Look, this thing is you are no longer an assembly member. So based on that, this assembly is properly.
Judgment, or in that order, did he, when he was giving that interlocutory order, did he clearly say, like Justice Wali said?
Yes.
Because now, if Danagogo declared the seats of Martins Amaewhule vacant, why then did Justice Wali in an ex parte order declare their seats vacant as well? That's the first question, because I asked you if it was an issue of speakership or an issue of vacancy. You said he died both.
Yes, I said the legitimacy, the speakership could not be arrived. You understand? If these people are the basis upon which.
Are you saying Justice Danagogo declared their seats vacant?
No, he affirmed that they are no longer assembly members, and therefore Okojumbo is the authentic speaker.
Affirmation.
Yes.
The same as declaring.
No, there is a declaration already. You understand? And it is based on those declarations that the speaker emerged. And Martins Amaewhule and co, we are challenging. They said, no, you people are no longer, the speaker, because you and your people have defected. So Okojumbo is duly elected the speaker, and he remains.
So what I want to get clear is that Justice Danagogo, in his order, made reference,
but
he did not declare their seats
because they've already been declared their seat.
Who declared their seats vacant?
It's the speaker. And the speakers are there. And I've told you that by the constitution, is the speaker.
You are the way you're explaining it, I'm getting it wrong.
No.
So that's why I'm seeking clarification.
It's okay.
Right. Now, the prayer, what was the prayer before Justice Danagogo?
Okay.
What was the prayer before Justice Danagogo by Edison?
The prayer by the Edison, this thing is that Okojumbo and his assembly member are the authentic, and yes, I'm saying Danagogo.
You're saying Okojumbo, it's Edison here and his assembly members.
Okay, that the Edison's matter is that once he was elected speaker, he declared the seat of the assembly or the other 25 assembly members seat vacant.
Okay, he declared their seats vacant before he became authenticated by Justice Danagogo.
Before Justice Danagogo now affirmed what was already existing.
So now that Edison has vacated his seat by the reason of resignation to become the chief of staff.
Yes. The remaining member of their assembly that were valid by that declaration remains Okojumbo and his people. Right. And that is where they derive legitimacy. So that's why I say you cannot isolate the declaration of their seat vacant and the existence of Okojumbo. There must be a precedent following, there must be a sequence following to getting to where they are.
If all that you explained happened, I'm trying to understand, then why did Okojumbo seek authentication of his speakership by the order of a court, the state high court? And what was the need for Justice Wale to declare the seats of Martins Amaewhule led House of Assembly vacant via an ex parte order when Justice Danagogo, according to you, had granted that prayer before?
When issues arise, even if there is an existing situation and you are in doubt, there is nothing wrong going for court for further interpretation or further reaffirmation to your understanding. And that is what they did. When there are issues, the Martins Amaewhule people, we are still sitting. So I have to resort back to court because I wouldn't take laws into my hand.
Right? If they adjourn sine die, what was the need to go to court? Because if they adjourn sine die, I mean, it means that they can convene anytime they want. It means that they adjourned to whenever.
Yeah, that you adjourn sine die does not mean that you will not
so
that you will not go to court.
They are still on.
No, that you adjourn sine die is that you've adjourned without taking the next date of sitting. That does not mean that you don't exist. That does not mean that you will not operate. They were operating, so they will go to court. That they
needed authentication from a court. They needed to authenticate.
No, there is nothing like authentication. I have told you, I have explained, you are still rephrasing it again. I said that if there is a dispute up to you are Laurencia, if I say, no, you are not Laurencia, you say, no, I am Laurencia, you are not Laurencia, what do? You go to court and say, look, forgive me saying I'm not Laurencia. No, I am Laurencia. And the court will do that. Does it mean that you've not been Laurencia before now?
If after I have gone to court and court declares that I am Laurencia, and probably your son wakes up tomorrow to say I am not Laurencia,
I won't fight him. I'll still go to court.
Hold on. Do I need to go to court or to go and fish out the judgment that was already there?
Yeah, even when I give you will dispute. So you need to go to court.
It is now your job to go and question whether I'm Laurencia or not, because already a court has given judgment. Why would I go to another court to give the same judgment?
So I have a matter that I'm doing now.
Yeah.
The matter went from customary court to Supreme Court, then to West African Court of Appeal. The matter came up about some years ago. With those documents, we went to court. When people were trying to interfere with the subject matter of that judgment, we went to court about that. The document we have was given in 1956. In about 2013 or thereabout, people were still doing the same thing, interfering with the subject matter. We went to court with the document. You understand? As of today, I'm telling you, people are still challenging that same thing again. And we're back to court to say, look, this is the sequence of the matter. Court gave, West African Court of Appeal, Waka gave the judgment in 1956. And in 2013-14, people challenged. We went to so court. This is what the court decided. We attach all those. And we are still in another court on same subject matter. So you keep on, as people keep on challenging you, you tell them, you show them the document, they will not. So you need further clarification, further declaration to their understanding.
All right. Very well. Barrister Sims, you wanted to say something?
See, the issue of Section 109, sub 1G, is being bandied by those who want to say the truth when it's convenient to them, without doing a community reading of that Section 109, sub 1G. There's a proviso. And that proviso is very clear, provided that his membership of the latter political party is not as a result of a division in the political party of which he put. Now, the question I have asked those who are saying, yes, he's been, who is supposed to determine whether a political party is in turmoil or is in tatters or has division? Is it the speaker that is an interested party? Is it the governor that is an interested party? Is it the chairman that is an interested party? These are the questions I've been asking. Nobody has been able to answer. But the speaker, who is part of it? You will not be a judge in your own matter. Is that what the principles of law and equity says? Is it the speaker that will say, no, there's no division in APC, there's no division in PDP? And they are saying there must be evidence showing this. Assuming I bring evidence to my office, are you the one that will determine whether that evidence is correct or not? This is the question I've asked. Very honest questions. In my own opinion, I believe it is the court that has that particular decision to make, being an independent arbiter. That is not an interested party. Because if I sit as a speaker and I am very angry and I see you move from my party to the other party, I will not even listen, I will just throw your seat away. But have you imagined a situation where in the National Assembly, people have defected, but the speaker, because they defected from another party to his own party, did not even invoke Section 109 or Section 68, as the case may be. I think in Akwa Ibom state or one of these states, almost all the members defected to PDP or APC or whatever the case may be. The speaker, nobody said anything about it. He did not even invoke. So which means the decision for the speaker to even declare the seat vacant under Section 109 is even discretionary under Nigerian politics now. It means the speaker, it would be, assuming, I'm just trying to give an example. If a year was, maybe he was the speaker, and about 10 people from APC are now joining PDP, he will keep quiet. So which means his discretion is that, they are doing a good thing. But because they have a political issue here now, you can see quickly he has gone to evoke and do whatever he's doing. These are the things I'm talking about. That Nigeria we're not doing democracy. The question I've asked is this: yes, the speaker has the right to do that, but does he have that immature, the baptismal right, like John the Baptist baptized Christ before going to preach? Does he have that right now to say, as it is, I will sit over my matter like Herod? Did he wash his hands up and say, whatever? So who's going to determine? If you bring a case to this person, King Solomon did it in the Bible. When two men were dragging to that one child, so okay, no problem, we are going to do this. But he used his wisdom to say, okay, let us divide to two parts. The other woman that said, please take. So there was an arbiter, that was an independent, a third party that had to settle these two people. So in that case, I am saying, I'm of the belief, sanctimonious one for that particular matter, that it's not baptismal, that the courts must do something about it, or another person, in fact, must do something about it. Independent man will look at whether the party has whatever or not. That is why in Amaewhule's case, it was the court that said, yes, what the speaker did was right, because there is no division in Labour Party. You understand the point? So I am saying this particular issue should be tested in court, and I'm very happy that it's in court. On the other issue of Danagogo, I want to say, I want to listen now. Danagogo did not give an interim order. He gave there was the interlocutory order. There was an interim order before Danagogo and also an interlocutory order. So the interim order has to be taken first. Then a date for the interlocutory now set. He now dispensed of the interim order, which is the expected order of 7 days. But the interlocutory, which is I have not seen it. I didn't see that order. That's number one. Number two is this: why did a year when he resigned and became chief of staff, why was the assembly, mute? Like a dormant volcano. Yeah? Why was he, mute? Mount Olympus is a volcanic, mountain, but it's mute for most part of the year and decades. One day we just erupt. Why did they say that particular assembly was now adjourned? Signed, dying. When a matter is adjourned, he doesn't even know the day. There's no date set. Because if you say 20th, it means it's not signed down. There's a date for that particular reconvening of the assembly. Assembly was we just say, go and enjoy yourself till we call you back. Now, when assembly, when they say definitely, it means there's no time that is set that they will reconvene. The only time that assignment can be, activated is when the registrar of court now call you and send message that matter is coming up on the 16th of June or July, or the clerk of the house, because they still work back on that ground. The Senate president will say, please fix a date for 16 for the convening of the house. The house has been in sign down since. It was in a moot mode, as case may be. So that has to happen. That, for me, that is what takes care of that particular, sign down. There was a reason for that, because it's true. Oko Jumbo felt, I don't think I have the premature authority, even though I have been baptized, but I can now carry on with this mission. He stayed and was obeying somebody until he came and said, come on, go and take over this place. He now ran and took over the place and sat like, this king of Agbo, that young boy. He sat on the stool and said, the next thing he did was, my stool is not safe. Oh. What did he now do? He now had to run to court, which the Court of Appeal set aside recently. The question we've asked now, and which you cleverly asked, if Okojombo had a floating and subsisting live wire, electric wire, when you put your eye, it will shock you. If it be so Okojombo had that kind of a thing, why did he go for another district, go on generator NEPA day? When NEPA don't give you like don't carry generator on it, don't be light to the look for. So I'm asking now, if there was an order that was substituting interlocutory, so let's read that matter. Why he can't go another court now? He now went to another court. Say, in that particular court he went to that Justice Wally. You know what is the release he was seeking for was that I am the substantive speaker of this House of Assembly. The listener should not begin to disturb me. But you said you have an interlocutor that says the matter there, nobody should touch and whatever as case may be. What now happened? So this is question we're asking, legal questions. But the other side, they don't want to hear. They are just listening. If you bring this matter now, they'll tell me to leave the radio station or go to anywhere and go and begin to drink water. But I don't know what I'm saying. If you don't follow their way of truth, open and close, they say you are a very useless person. It's wrong. These are the pertinent questions. We don't need Nostradamus to come and tell us. We don't need Autolycus to come and interpret. We don't need a seer that told and asked Julius Caesar that talks about the Ides of March. We don't need people like that. This is very clear as crystal clear. Even as a man that is blind can even listen and say, okay, I'm listening to you, but I know that rain won't fall because thunder they strike. This thing, as you are saying, I know the read though, but I feel cancel them. Finally, do you know what these people are doing right now in this River State? Because this River State, this is getting me worried. They believe that what they cannot get in the legal roundabout, they will get in the political arena. That is why you see executive governor jumping and aiding them. The question I've asked is this. If we run a conscionable government, me as a governor, I'll go and present a budget, 800 billion. I'll go and run to people who are three. How does the room even look? How does the room even look? If you go to a court now, my colleague, I'm asking now, you go to that court now, only one judge is sitting, road, no register, no clerk. All of the judges looking at you say, Oga, help me bring that file for me. You will ask a question, Oga, what happened to your court now? So how do you now go and present a budget, say 3 people? They were carrying that box like, I thought they were doing a skit. If you saw the way they were carrying that box that day, I'm sorry. They were carrying the box, the budget. I said, this is River's budget. They say, yes. That's what I said. They say, yes. The one man will say, yes. Speaker is coming to this. I look at this person. Oh my God. I look around, nobody. Yeah, please, if you look at the way these people are sitting, you see activity, you see joy. National Assembly, where they sit, you see Senate, where they are sitting. You will see joy, you will see activities. But in River State, only 3 people making laws for all of people, 5 million people. In fact, now monarchy, now they operate here, not be this thing.